Imagine standing in a stone chamber, where screams echo against cold walls, while robed officials calmly record each confession extracted through methodical application of instruments designed not merely to inflict pain, but to transform agony into legal proof, where the systematic destruction of human bodies is conducted with the ceremonial precision of religious ritual and justified through elaborate philosophical frameworks that present suffering as the most reliable path to truth. This was not the realm of sadistic monsters or primitive barbarians, but the calculated legal philosophy of Europe's most educated minds, theologians, jurists, and scholars who constructed comprehensive intellectual systems that transformed torture from crude violence into sophisticated jurisprudence, creating academic theories that made systematic cruelty appear not only legally necessary, but morally virtuous in service of a justice system that claimed divine authority while serving distinctly human purposes of social control and institutional power. From the universities of Bologna and Paris to the cathedral schools of Salamanca and Oxford, learned men crafted elaborate treatises explaining why the deliberate infliction of unbearable suffering represented the highest achievement of legal science, developing theological arguments that portrayed torture as divine revelation, philosophical frameworks that made pain synonymous with truth, and procedural manuals that transformed the human capacity for cruelty into precise technical instruction, for the systematic extraction of confession through the strategic application of fire, water, crushing, tearing, and psychological terror. These intellectual frameworks were not mere justifications for predetermined brutality, but genuine attempts by some of history's most sophisticated thinkers to resolve fundamental problems of legal epistemology. How could courts determine truth when witnesses lied? Evidence was scarce, and the stakes of wrong decisions included eternal damnation, social chaos, and political instability that threatened the very foundations of Christian civilization and social order. The Roman legal foundation provided the intellectual architecture upon which medieval torture jurisprudence was constructed, as Roman law had established the principle that slaves could only testify under torture because their social status made them inherently unreliable witnesses, whose testimony required physical coercion to achieve truthfulness. This ancient precedent created legal frameworks that associated pain with authenticity, suffering with reliability, and physical coercion with judicial necessity, establishing conceptual foundations that medieval jurists would expand into comprehensive systems for extracting truth from all social classes through the systematic application of controlled violence. The Digest of Justinian contained detailed provisions governing the use of torture in legal proceedings, including specifications for appropriate methods, limitations on duration and intensity, and requirements for official supervision that provided medieval lawyers with authoritative classical precedents for torture as legitimate legal procedure rather than crude violence or arbitrary punishment. Roman legal theory held that extreme circumstances, crimes against the state, threats to social order, accusations involving supernatural forces, justified extraordinary investigative methods that superseded normal protections for individual physical integrity in service of discovering truth that could not be obtained through conventional legal procedures. Medieval jurists interpreted these Roman precedents as divine providence, arguing that classical legal wisdom had anticipated Christian legal needs by providing frameworks for torture that could be adapted to serve religious truth and ecclesiastical authority while maintaining the appearance of continuity with ancient legal tradition. The revival of Roman law in medieval universities created academic environments where torture was studied as sophisticated legal science, requiring extensive education in classical texts, theological principles, and procedural technicalities that transformed physical violence into intellectual discipline worthy of scholarly investigation and professional specialization. The theological justification for torture, developed by medieval scholars, created comprehensive religious frameworks that portrayed systematic suffering as divine revelation, arguing that God permitted or even commanded the use of physical coercion to extract truth that would otherwise remain hidden beneath human deception and diabolic influence. Thomas Aquinas and other scholastic theologians argued that torture served divine justice by compelling sinners to confess crimes that threatened Christian society, reasoning that temporary physical suffering was justified to prevent eternal spiritual corruption that would result from allowing evil to remain concealed and unpunished. The concept of purgation through suffering provided theological foundations for torture as spiritual purification, suggesting that physical pain could cleanse souls of sin while extracting confessions that served both earthly justice and divine will, creating intellectual frameworks that made torture appear spiritually beneficial for both society and the individuals subjected to systematic violence. Medieval theologians developed elaborate arguments about the relationship between physical pain and spiritual truth, claiming that bodies corrupted by sin could only reveal divine truth through suffering that stripped away the deceptions and self-interest that prevented honest confession of crimes against God and community. The Inquisition provided institutional frameworks for implementing theological torture theories, creating professional bureaucracies dedicated to extracting confessions through systematic violence, while claiming religious authority for procedures that served obvious political purposes of suppressing dissent and maintaining ecclesiastical power over temporal authority. Religious authorities argued that heresy represented such severe threats to Christian civilization that extreme investigative methods were not only justified, but morally required to protect innocent souls from corruption and defend divine truth against diabolic deception that could only be overcome through physical coercion applied with spiritual authority. The legal philosophy of truth, underlying medieval torture jurisprudence, held that human beings possessed natural tendencies toward deception, self-preservation, and moral corruption that made voluntary confession unreliable, while physical suffering provided direct access to authentic truth that bypassed conscious will and rational calculation. Legal theorists argued that extreme pain created psychological states where defendants could not maintain lies or deceptions, forcing them to reveal genuine knowledge and authentic guilt that remained hidden during normal questioning that allowed time for calculation, consultation, and strategic deception. The concept of confessio regina probationem, confession as the queen of proofs, elevated extracted confessions above all other forms of evidence while providing intellectual justification for torture as the most reliable method of obtaining the highest quality legal proof available to human courts seeking divine truth. Medieval jurists developed elaborate epistemological theories explaining why voluntary testimony was inherently unreliable, while confessions obtained through systematic suffering provided access to authentic knowledge that could not be achieved through rational inquiry witness testimony or physical evidence that could be falsified or misinterpreted. The inquisitorial procedure created comprehensive legal frameworks that integrated torture into systematic judicial processes designed to ensure fair and thorough investigation of crimes that threatened social order and religious orthodoxy, establishing procedural safeguards intended to prevent abuse, while maintaining effectiveness of physical coercion as investigative technique. Legal manuals specified requirements for judicial approval before torture could be initiated, limitations on methods and duration of application, medical supervision to prevent permanent injury or death, and multiple opportunities for voluntary confession that would eliminate the need for physical coercion altogether. Thur Malleus Maleficarum and similar inquisitorial handbooks provided detailed technical instruction for conducting torture sessions, including specifications for appropriate instruments, optimal techniques for different types of suspects, and procedural requirements designed to ensure that extracted confessions met legal standards for reliability and authenticity. Courts developed elaborate bureaucratic systems for documenting torture sessions, including detailed records of methods used, confessions obtained, physical evidence discovered, and official justifications for each escalation of physical coercion, creating archives that demonstrated systematic compliance with legal requirements while providing precedents for future cases. The theory of graduated suffering provided intellectual frameworks for escalating torture intensity based on the seriousness of accusations, social status of defendants, and quality of evidence already obtained, creating systematic approaches to physical coercion that claimed scientific precision while serving obvious functions of class discrimination and political manipulation. Legal authorities distinguished between torture, light torture ordinary and torture extraordinary, creating technical categories that appeared to limit suffering while actually providing flexible frameworks for applying whatever level of physical coercion authorities deemed necessary to obtain desired confessions or eliminate unwanted individuals. The social class considerations in medieval torture jurisprudence revealed the systematic nature of legal discrimination, disguised as procedural fairness, as legal systems typically prohibited or limited torture of nobles, while applying it extensively to commoners, creating hierarchical justice systems that reinforced existing social arrangements through differential application of systematic violence. Wealthy defendants could often avoid torture through financial payments, legal technicalities, or social connections that demonstrated the economic and political functions of torture systems that claimed to serve abstract justice while actually maintaining concrete power relationships through the selective application of systematic suffering. The gender dimensions of torture jurisprudence created specialized legal frameworks for subjecting women to systematic violence while claiming scientific authority for procedures that reflected and reinforced patriarchal assumptions about female nature, truthfulness, and appropriate treatment under legal investigation. Women faced gender-specific torture methods, including sexual humiliation, reproductive violence, and psychological techniques designed to exploit presumed female weaknesses, while male authorities claimed expertise in extracting truth from female defendants who were presumed to be inherently deceptive and morally unreliable. The witch trial procedures developed elaborate torture protocols specifically designed for extracting confessions from women accused of supernatural crimes, creating legal frameworks that use systematic violence to generate evidence for crimes that existed primarily in the imagination of male authorities seeking scapegoats for social problems beyond their control or understanding. Female defendants in witch trials faced torture methods that were explicitly designed to extract confessions of sexual relationships with diabolic forces, creating judicial procedures that used systematic violence to generate pornographic narratives that served the psychological and political needs of male authorities, rather than legitimate legal investigation. The international variation in torture jurisprudence reveals how different legal systems adapted similar theoretical frameworks to serve local political needs while maintaining intellectual coherence through shared commitment to torture as legitimate investigative technique rather than arbitrary violence or cruel punishment. French Parliament developed elaborate procedural requirements for torture application, including multiple judicial approvals, detailed documentation requirements, and formal review processes that created appearance of legal restraint while ensuring systematic application of physical coercion against political enemies and social undesirables. Spanish Inquisition procedures integrated religious authority with secular law enforcement to create comprehensive systems for extracting confessions from religious minorities while claiming divine authorization for systematic violence that served obvious political purposes of ethnic cleansing and property confiscation. English common law typically prohibited torture except in cases of treason and threats to royal authority, creating legal exceptions that demonstrated the political functions of systematic violence while maintaining national identity based on rejection of continental torture practices that were portrayed as foreign corruption. Germanic legal traditions often emphasized ritual combat and ordeal procedures as alternatives to torture. Though these systems still relied on systematic suffering to extract truth, while claiming supernatural rather than human authority for judicial violence that served similar social control functions. The resistance and criticism that emerged against torture jurisprudence demonstrates that medieval society included voices that recognized the systematic cruelty and political manipulation disguised as legal science. Though these critics often faced persecution for challenging legal systems that claimed religious and intellectual authority, canon law scholars developed arguments against torture based on theological principles emphasizing divine mercy and human dignity. Though these positions were typically marginalized by institutional interests that benefited from systematic violence disguised as religious duty and legal necessity. Humanist legal reformers during the Renaissance began systematic criticism of torture jurisprudence. based on classical precedents that emphasized rational inquiry and evidence-based legal procedure, though their influence was limited by political authorities who valued torture as a tool of social control rather than legitimate legal investigation. Popular resistance to torture took forms of community protection for accused individuals, systematic non-cooperation with judicial authorities, and emigration from regions where torture was extensively practiced, demonstrating widespread recognition that legal torture served political oppression rather than genuine justice or social protection. The decline of torture jurisprudence occurred gradually through combination of intellectual criticism, political calculation, and practical recognition that systematic violence generated unreliable confessions while creating social instability that threatened rather than protected existing power arrangements. Enlightenment legal theorists, including Cesare Beccaria, developed comprehensive critiques of torture based on rational analysis of its effectiveness and social consequences, arguing that systematic violence corrupted legal systems while failing to achieve stated goals of truth discovery and crime prevention. Political authorities gradually abandoned torture as investigative technique when they developed alternative methods of social control that were more effective for maintaining power while avoiding the administrative costs and social unrest associated with systematic judicial violence. The modern legacy of medieval torture jurisprudence can be seen in contemporary legal systems that continue to rely on coercive interrogation techniques, psychological pressure, and systematic suffering disguised as legitimate investigative procedure while claiming scientific authority for methods that serve political rather than judicial purposes. Understanding the intellectual frameworks that justified medieval torture provides crucial insight into how sophisticated legal and religious institutions can transform systematic cruelty into apparently legitimate procedure while serving institutional interests rather than genuine justice or social welfare. The historical experience with torture jurisprudence demonstrates that legal systems must be evaluated based on their actual functions and consequences rather than their stated purposes and theoretical justifications, revealing the importance of maintaining skepticism toward institutional claims about the necessity and effectiveness of systematic suffering in service of abstract goals. Contemporary interrogation techniques, psychological coercion, and legal procedures that rely on systematic pressure to extract confessions often reproduce the essential features of medieval torture jurisprudence, while claiming scientific rather than religious authority for methods that serve similar functions of social control and political manipulation. As you contemplate these comprehensive intellectual systems that transform systematic cruelty into sophisticated legal science while claiming divine and rational authority for procedures that served obvious political purposes, consider how contemporary legal institutions continue to use similar justifications for systematic suffering disguised as legitimate investigative technique or social necessity. The medieval experience with torture jurisprudence reveals that the human capacity for rationalizing cruelty is unlimited when it serves institutional interests, while demonstrating the importance of recognizing and resisting legal systems that claim moral authority for procedures that systematically violate human dignity in service of political rather than judicial goals. If this exploration of the intellectual foundations underlying systematic judicial torture has revealed patterns of institutional rationalization that extend beyond historical contexts into contemporary legal and political systems, share your insights, subscribe for more investigations into the mechanisms of systematic cruelty disguised as legitimate authority. And remember that understanding how sophisticated institutions justify systematic suffering provides essential knowledge for recognizing and resisting contemporary forms of legal violence that claim scientific or moral authority for obviously political purposes. Would you have recognized the political and economic motivations behind elaborate intellectual justifications for systematic torture, while living under comprehensive legal systems that claim divine and rational authority for procedures designed to serve institutional power rather than genuine justice or social welfare?